Hi, my name is Alex Dolphin. Welcome back to another episode of Ex Ante. Today we're going to discuss the case United Housing Foundation versus Forman. This case was heard in the Supreme Court of the United States in 1975. Let's go ahead and jump into the facts of the case. So the plaintiffs here were citizens of New York that had purchased stock in a co-op. The idea is that if you buy stock, it will give you the rights to occupy a room in the future in this massive housing complex that was being built. So the folks, United Housing Foundation, that are building this co-op essentially raised a portion of money by selling stock to the public. And then this stock would in turn give the public the right to occupy one of the rooms in the housing co-op that they were building. Now, the co-op was also funded by mortgages, and it was heavily subsidized by New York State in a law that they passed to try and improve affordable housing for the people in New York. So this stock that the people were buying, basically what it gave you rights to a room. You couldn't sell this stock unless the housing foundation was given a right to buy it back at the original price. And you really couldn't transfer it to anyone except for a surviving spouse. Although it was called stock, that was a strong word for what this really was, these shares in the co-op. Now, what happens is the co-op comes in over budget. And so people that bought these shares in the co-op were promised a rental rate that was lower than what they were actually forced to pay in the future. And that's because the people who were building the co-op came in over budget. They had to pass on those costs to the people who were living in the apartments. And so the owners of the stock were obviously angry because now they had to pay additional money to live in this place that they were guaranteed. And they felt like they were guaranteed this rate that they were told when they purchased this stock, and that rate had gone up after the housing co-op was finally built and when they moved in. So they alleged securities fraud, and they say, you defrauded us when you lied about what the rent was going to be when you sold us this stock. And the Housing Foundation says, well, although it's called stock, this isn't really a security within the meaning of the Securities Act of 1933. So federal court doesn't have jurisdiction. This case should be dismissed. And so that's the heart of the dispute, whether this co-op housing stock is actually a security within the meaning of the securities laws of the United States. And in the district court, they rule in favor of the Housing Foundation. They say, no, this isn't a stock. There's no expectation of profits as an investment contract, and it's just not a stock within the meaning of the act. The Second Circuit Court of Appeals reverses the district court, and they say, one, this is a stock, right? It's called stock. It's called co-op stock. The Securities Act defines a security as any stock. And so it's within the Securities Act. It's that simple. They also say that even if, this doesn't fall under the term stock in the Securities Act, it's an investment contract. And under the Howey test from a famous case, SEC versus Howey, this is still a security because there's an investment of money. When the people buy the stock, there's a common enterprise, which is the management team that is running this whole housing co-op. There's expectation of profits, and this is the most controversial place we'll dive into later, because the people are going to receive decreased rent with this stock. And then there's efforts of others that are giving those purchasers of the stock a profit, because there's a management team that's operating the whole co-op, if you will. So Supreme Court takes this up, and they hold that this co-op stock is not a security within the meaning of the Securities Act. And so first off, Justice Powell has to get around what looks to be a pretty strong textualist argument that if Congress passes a law that says any stock is a security, well, this is a stock, why is it not a security? And he says, essentially we're going to look at the economic realities of the transaction. Just because something's called stock doesn't mean it's necessarily a security. It probably will be, but he says here, we got to look at the economic realities, and here those tend to show us that this shouldn't be within the definition of the Securities Act. It's also worth noting, Justice Powell doesn't talk about this in his decision, but even in the act, there's a portion that says unless otherwise requires. So he could have used that to kind of just shoehorn his argument and say, well, the context requires otherwise here. This stock is not technically a security. Congress wasn't envisioning this when it was writing the Securities Act of 1933. And so from that perspective, this really is kind of a purposivist or an intentionalist type of judicial interpretation. The court, Justice Powell, is looking at what was Congress intending to do? Were they trying to regulate this? No, not when they said stock. Then he has to deal with the more nuanced, complex argument of the investment contract. And so he says, clearly there's an investment of money when they buy the stock. Clearly there's a common enterprise because there's a team that's managing this housing, and that would be the team that's providing the efforts to increase those profits. So under Howey, but ultimately where he thinks that this fails under the Howey test, and where the court says, is that there's no reasonable expectation of profits. That is the key aspect of this case. And he writes it right there that when someone purchases something for consumption rather than to increase in profits, then that thing's not going to be an investment within the meaning of the Securities Act, right? And he's saying that the purchasers of these co-op stock, they weren't expecting any profits. They were buying this stock because they wanted to occupy the rooms in the co-op when it was finished being built. And he turns to a few factors for that. Mainly, he just says, tax deductions, that's just New York City. That's not really a profit to the buyers of the stock. And then I think the most important aspect is that you can't transfer this stock without the co-op rubber stamping it. And you can't transfer it at an increase in value. If you're going to transfer, you have to transfer it at $25 per share, which is originally what you bought this co-op stock for. So there's no way to really profit on the shares. The only way you would profit is in decreased rents. And he says those decreased rents, they're too attenuated. That's not enough to classify these co-op shares securities within the Securities Act. That expectation of a decreased rent is not akin to an expectation of profits to make something a security. So the key to glean from the majority's opinion is that if something is being purchased for consumption rather than for an investment opportunity, rather for some type of way to appreciate in value or receive dividends from the profits, well, then it's probably not going to be a security under this holding in Forman. There's a dissent, which is kind of interesting to see the liberal bloc of justices basically giving a textualist argument here. They're saying, look, the Securities Act says stock. The co-op housing stock is called stock, so it's a security. Simple as that. 2 + 2 = 4. They also say that this is an investment contract because the decrease in rent would qualify as expectation of profits. So within the minority's reading. So you can see that there's definitely some wiggle room where the two sides disagreed, but the majority came down saying that that tax deduction, that decrease in rent is not enough to make this stock a security within the meaning of the Securities Act. So this case could be valuable when you're thinking about things, like sneakers. Sneakers, a lot of people buy sneakers on StockX or local marketplaces and try and buy them because they want to resell them in the future. Basically, they're having expectation of profits. That would probably be something where the court would look at that and say, these people are purchasing this to consume it. Sneakers are consumable. You wear them. And so thinking that that's going to be a security, probably not. Of course, there's other reasons to think that wouldn't be a security under the Howey test as well, but just to kind of tease that out. When you think about cryptocurrencies and NFTs would be something where this could also come into play, where if that NFT was really a consumable, truly a piece of artwork that you couldn't really profit off of, or if it was used as a ticket to get into a sporting event, something like that, well, then it's for consumption. And so the securities laws probably wouldn't apply in that type of an instance. So that's the case. Thanks so much for watching. It gives you a lot to think about. Where is the line between consumption and investment, and where would the securities laws apply? And I think this court decision gives us a little bit of an insight into the Supreme Court's reasoning and what might occur in the future with future new assets and schemes that are drawn up, and whether the court might classify those securities or not. So thanks so much for watching. I hope you have a nice rest of your day. And if you enjoyed this video and would like to see more, go ahead and hit that subscribe button. And I'll talk to you soon.